if you see the directions which we have issued at page 76,
My lord.
we have not told you to do the matching exercise. We have asked you for a plain disclosure. Therefore, the ground on which you seek an extension of time to make the disclosure does not accord with the directions in the judgment at all. The judgment doesn't tell you to do that.
No, my lord, I'll tell my lord what we understand. If that is not so, then of course there is no problem. If your lordship is pleased to turn to para 221.
But then you simply comply with the judgment.
No, please turn to para 221. Your lordship's judgment?
Page 76, right?
76, yes. SBI shall submit details of electoral bonds purchased since the interim order of the court. Well, no problem. No problem. The details shall include the date of purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchase. Now, my lord, when the purchases were happening, we divided the information. The name is kept at one place and the purchase is recorded at another place.
But ultimately, everything was sent to the Mumbai Central Main Branch. All issuing branches, for the political parties, there are only 24. Actually, there are 4. But insofar as the purchasers are concerned, everything has been remitted back to the Mumbai Central Main Branch.
Except, I'm sorry, my lord, your lordship is right. It is not kept at one place because the reason, if your lordship just sees an earlier para, my lord was pleased to see para 10. If your lordship just sees para 5 and 7, that's why the problem has arisen in this case. Para 5 said central government framed the electoral bond scheme, which provided that the information furnished by the buyer shall be treated as confidential, and the bank shall not be disclosed by any authority for any purpose. Now, my lord, we knew this is sensitive information, so a physical procedure was devised. You sort of did a KYC and you kept the name in that. And once that was cleared, then only the bond number was cleared, and then the bond number was used for further purchases. The money came to people who didn't know who the money was, who was the real name of the purchaser. They just knew this was a cleared account, so it came into a bond payment account, and from the bond payment account it was given. And it was done precisely, my lord, to prevent this kind of gossip coming out saying so-and-so has purchased so much. Now, my lord, para 7, if you see the SOP, because this is not something we've done now, my lord, this is the original SOP, said no detail.
Ultimately, even your FAQs, which were shown to us during the course of the hearing,
Yes.
the FAQs indicate that for every purchase, you have to have a separate KYC.
Yes, we have that. We have that.
Therefore, it's very clear that every time somebody made a purchase, a KYC was mandated. That one set of documents, namely the electoral bond application form, KYC documents, citizenship documents, and pay-in slips.
There's no issue. We have the details. Please don't misunderstand me.
Therefore, you have the details.
No, I have the details. I'm sorry. I'm not saying it's not there.
One minute, Mrs. Salve. Now, paragraph 10, you specifically say that all the purchases details have been kept in a sealed cover.
Yes.
In the main branch of the applicant bank.
Correct, my lord.
You just have to simply open up the sealed cover and collate the names and give the details.
My lord,
as far as paragraph 11 is concerned, you're saying that the donees' details are being kept in a sealed cover, envelope in a sealed cover. Open up the sealed cover and give the details. In fact,
tell my lord where the only bit of information.
If I'm not mistaken, the EC was asked to file an affidavit, which you in a sealed affidavit or details in a sealed envelope, which we have not opened. With regard to the donor details and other details during the course of hearing, which they may have filed.
My lord, my problem is this, my lord. With respect, in fact, just responding to what my lord has said, I have full details of who purchased the bond, but that's put in one silo of information. I have full details of where the money came from, which is in a second silo. And I have a complete detail of which political party tendered how many bonds and who has been paid how much. That's a easy ask. That can be given straight away. The problem is, my lord, I have to now put the name of the purchaser, which is in the first sealed packet, and these are all physically kept. They were not put into the banking system. Each form will have to be taken out, the name checked, that name now correlated to the payment detail, and the payment detail correlated to the bond, and finally that's where the bond number gets generated, and then we can connect as to which political party who has given that money. Now,
That has not been asked, Mr. Sarve.
but my lord, I have
There
to
is a
give
direction to correlate it with the purchaser and the political party.
my lord, para 76 does suggest that. Would your lordship just see it for a moment, if you lordship?
Don't go by what is suggested. Whatever you wanted to speak, we have spoken in black and white.
No, in that, my lord, your lordships, please see that sentence. I'm not, my lord, we have no desire at all to try and expand our own job, my lord. Please see page 76. This by itself is creating difficulties. My lord, your lordship say the detail shall include date of purchase of a bond, no problem. But the moment I have to give the detail of the name with the bond number, that is taking time because we had deliberately put these in two silos. If your lordships want only the details of who purchased the bonds, we can give that straight away.
Mr. Sarve, our judgment is dated 15th of February 2024.
Yes, ma'am.
We are now on the 11th of March.
Yes, ma'am.
In the last 26 days, what extent of matching has been done by you? What steps have you taken in the last 26 days? The application is absolutely silent on that.
We can put a detailed affidavit on that, my lord, because I know
it should have been disclosed in the affidavit.
I agree, madam. I agree.
State Bank of India, which is coming to us, we expect that there should be a degree of candor on the part of the State Bank of India. That this is what the work which we have done. The work is at this stage. We need an extension of time to carry out the balance of the exercise which remains.
Lord, we have sought to explain the problem, and the work is going on. Because, my lord, each form, it'll have to be form by form.
It is going on to what extent you have reached?
My lord, work is going on form by form. They will, if your lordship's on, I can give the exact detail of how many we have covered and how many more we can cover. But they did a rough calculation, my lord, it'll take about 3 months more. Because I'll tell you, my lord, my other concern. I have another big concern, my lord. I cannot make a mistake in this. I'll get sued by the donor. I'll get sued by people because I cannot by mistake say A got it when B had it.
Highest court of this country. So where is the question of you being sued?
I'm sorry, my lord.
Whatever you are doing under the directions of the highest court of.
No, my lord. If I make a mistake, if I say Mr. X got it instead of Mr. Y got it in a hurry to give the numbers, I could create havoc there, my lord, because ultimately.
As we take it, Mr. Salvi, you are accepting that there's no difficulty in giving names of the donors who purchased the bonds and the amount they purchased the bonds. You have got no difficulty in giving details of the political parties who have purchased the particular bonds. The only difficulty is matching the purchased bond with that. But 26 days, you must have carried out at least some, say, 10,000 bonds you have been able to collate, 5,000 bonds you have been able to collate.
Quite frankly, what I saw, they were struggling with it. They were making charts which we saw were not matching. I'll tell you what has happened. No, I'll tell you candidly what has happened.
If I'm not mistaken, it was pointed out to us that the bonds had some number which under some instrument they were able to.
Yes. But that number.
That's all has to be done.
That number is not to be found in the application for purchase or in the first set of documents. The problem is that number, when number was generated, that number has been scrambled and put elsewhere, and that number has been kept secret. Now, putting that will require tracing it into each transaction. At the stage of the interim order, and I'm saying what happened at that time. The kind of information which your lordship asked was a macro information. So that is no problem.
In pursuance of the interim order,
Yes.
Election Commission of India has filed, details before us.
Or whatever they have.
In separate silos, if we can use that expression.
Yes.
The ministry has placed that, in secured custody with us. We'll direct them to open it here right now, because since we were deciding a point of constitutional validity, we didn't consider it necessary either during the course of the hearing or thereafter. So we can ask them to open it, and we'll ask the Election Commission of India to divulge whatever there is, and we'll ask SBI to then divulge what we are on notice. That this court may be inclined to proceed against it for willful disobedience of the judgment. if SBI does not comply with the directions of this court as set out in its judgment dated 15 February 2024 by the timelines indicated in this order. Full stop. The miscellaneous application for extension of time shall accordingly stand dismissed. Contempt petitions shall stand disposed of at this stage in the above.